Plea bargain is an arrangement between prosecutor and defendant whereby the defendant pleads guilty to a lesser charge in exchange for a more lenient sentence, or an agreement to drop other charges. Plea bargains are also called negotiated pleas or just deals. There are three forms of plea bargaining. Number 1, sentence bargaining is a method of plea bargaining in which the prosecutor agrees to recommend a lighter sentence for specific charges, if the defendant pleads guilty, or don't contest to them. It involves assurances of lighter or alternative sentences in return for a defendant's pleading guilty. One of the most visible forms of sentence bargaining occurs when defendants plead guilty to murder in order to avoid the death penalty. Second type is charge bargaining, is a method where prosecutors agree to drop some charges or reduce a charge to a less serious offense in exchange for a plea by the defendant. Third type of plea negotiation is count bargaining, in which defendants who face multiple charges may be allowed to plead guilty to fewer counts. The charges need not be identical. The prosecutor may drop any charge or charges in exchange for a guilty plea on the remaining charges. Because count bargaining applies only to defendants who face multiple charges, as criminal courts become ever more crowded, prosecutors and judges alike feel increased pressure to move cases quickly through the system. Criminal trials can take days, weeks, or sometimes months, while guilty pleas can often be arranged in minutes. Also, the outcome of any given trial is usually unpredictable, whereas a plea bargain provides both prosecution and defense with some control over the result. Plea bargaining is very common. More than 90% of convictions come from negotiated pleas, which means less than 10% of criminal cases end up in trials. When are plea bargains negotiated and made? In most jurisdictions and courthouses, plea bargaining can take place at virtually any stage in the criminal justice process. Plea deals can be struck shortly after a defendant is arrested and before the prosecutor files criminal charges. Plea negotiations may culminate in a deal as a jury returns to a courtroom to announce its verdict. If a trial results in a hung jury in which the jurors are split and cannot make the unanimous decision required, the prosecution and defense can negotiate a plea rather than go through another trial. And plea deals are sometimes reached after a defendant is convicted while a case is on appeal. In the United States, research has shown that defendants who plead guilty receive less severe sentences than similarly charged defendants who exercise their right to trial. The role of judges: in some jurisdictions, prosecutors and defendants can work with judges to predetermine what sentence the defendants will get if the defendants accept plea bargains. In most jurisdictions, however, judges' role in plea bargaining is limited. Federal judges may not be directly involved in plea bargain negotiations. Plea bargaining is a completely private process when it takes place. This means that no one besides the defendant, the defense counsel, the prosecutor, and sometimes the judge are present in the conference room, not even the victim of the defendant. The details of a plea bargain are not made known to the public until the bargain has been agreed upon by all sides involved. What if someone violates a plea bargain? Courts treat plea bargains as contracts between prosecutors and defendants. A defendant breaking a plea bargain is akin to a breach of contract, which will result in the prosecutor no longer being bound by his or her obligation in the plea deal. If a prosecutor reneges on plea bargains, defendants may seek relief from the judge. The judge might let the defendant withdraw the guilty pleas, may force the prosecutor to follow the plea bargain. The four main reasons that a plea bargain is offered by the prosecutor to the defendant are: defendants can avoid the time and cost of defending themselves at trial, the risk of harsher punishment, and the publicity a trial could involve. The prosecution saves the time and expense of a lengthy trial. Both sides are spared the uncertainty of going to trial. The court system has saved the burden of conducting a trial on every crime charge.